your assets at your death. Also then, we speak about an estate. What do I mean when I say an estate? While you are a living body within our country, you are able to acquire assets and incur debts. That whole process of acquiring assets and incurring debts forms an estate. So uNomfundo Madonsela has an estate, and all the people that are on this call have an estate. When you are married, let's say you're married in community of property, two estates come together and we say that we have a joint estate. So that is what we mean when we keep referring to an estate. Now, in estate planning, a will is but a tool for us to achieve estate planning. Let's look at the other tools that are applicable to estate planning. So we have will, which we'll talk about a little bit more later. We have trusts. You can have a living trust. You can have a trust that you establish in a will, which is there to preserve assets for a group of beneficiaries. And so that's also a tool within estate planning. A power of attorney. What do I mean by a power of attorney? Let's say now something were to happen to me and I become, what is the word, incapacitated, and my mental functions are not completely there. Somebody needs to step into my position and be able to take legal action that is recognized by the law. So a power of attorney essentially is there where you've appointed somebody that should something happen to you, they are able to still carry on your affairs, signing off of accounts, major decisions that need to have a legal document, that person would be able to do. Marital regimes, I know this is something that we shy away from, even I'm not even sure why, considering marriages in community of property versus out of community of property. You need to understand what is the implication. If I'm married in community of property, you must understand it's a joint estate. If something happens to the one spouse, the other spouse is affected. The death of the one spouse affects the joint estate. So in estate planning, essentially, we are considering all of these various scenarios in terms of marriages. Then also a living will is also part of estate planning too. What is a living will? So let's say now something, God forbid, would happen to me and I am on life support. People need to know when to switch off the machines. That is all contained in my living will. How I would like to be buried, or if I want to be cremated, whatever, you can use a living will to achieve that process. Now, when we are talking about the process of estate planning, you can't do it as an individual. Yes, you can. Yes, you can. But it is good to involve attorneys and involve financial advisors and also tax specialists who will be able to assist you to look at your estate holistically and help you to put things in place that will effectively preserve your assets and make sure that when something happens to you, there is an equal and a beneficial distribution of your assets. So I hope we all understand what estate planning is now. So I thought to share this. I saw it last week on one of my clients' statuses, and I actually went to her and I said, ma'am, do you mind if I share this with a group of people that I'll be speaking to over the weekend? She said, sure, please go ahead, because she had basically drafted out the whole scenario on her status, on her WhatsApp status. But the punchline is my life changed in an instant. So what happened in this instant is it was her birthday, and her husband and her children had gone out. They'd taken her out for her birthday. After that, she went for a walk with her husband. They came back home. And during the walk, she says they were actually planning their life. It's about 5 years ago. They were planning, we need to do this. We need to put this in place. We need to save more and do this and that. And she was really excited. It happened in the month of January. She was excited for the year ahead. And she says then she went to bed, and after a while she realized, no man, this man is not in bed. She woke up and she went to the living room and she actually found him, that he was ice cold, according to her narration to me. And that's when it all changed. The moment she called her husband's family to come over and assist because her husband was dead, it all changed. Immediately then Monday, the next week, we were in high court issuing court applications because the family is now fighting her. They're taking the body. They, after a while, even started challenging that she should not inherit in terms of his interstate estate. In other words, he had no will. The crunch line, or the punchline again, that she was trying to share with the audience who were reading, is to say, prevent interstate succession by getting a valid will in place. She said she cannot emphasize this enough. She found herself in a detrimental position because immediately, imagine, to this day, she does not know where her husband is buried. And she's had to grieve and move on and fight people who are saying, no, this asset does not belong to you and whatnot. And mind you, this was a happy family. I mean, they were singing Kumbaya in church, holding hands with the people who are now attacking her. So things can literally change in an instant. We don't want to leave things to chance. It is important to have your will, ladies and gentlemen, in place and to ensure that it is valid and has your express intentions. So that moves us to then the next slide. What is a will and what other valid requirements? What are the requirements for a will to be valid? A will is a testament, or sometimes we call it a last will and testament. And essentially, it's a legal document that says, when I die, should I die as the testator? That's the word that we use when we call the person who's drafting a will. What must happen to my assets? How must you distribute everything that I have? And there are, in terms of the Wills Act, there are certain requirements that this document must fulfill in order for it to be valid. So the person who's drafting the will must be 16 years of age. The will must be in writing. You can't tell somebody to tell someone that these were your express intentions. No, it cannot be. It must be in writing. It must be signed by the person who is saying what ought to be happening with the estate. So if I say I leave my house and my car to whoever, I must be the person who signs, and I must sign the document in the presence of two competent witnesses who are present together when I sign the document. Also, I am able to sign. So you can't say, because I can't write, I can't have a will. You are able to sign using a mark or your thumb. But in that instance, then you must do so in the presence of a commissioner of oaths who will then attach a certificate to the will confirming that this mark was made by person X. And indeed, they signed in the presence of these two witnesses, and then they commission the document itself. And it must be made voluntarily. You can't force a person to make a will. You can't go to your mom and put undue pressure on her to make your will now and leave everything to me. That creates grounds for that will to be contested. Should it ever arise that somebody found out that you actually applied undue pressure on the person to draft the will. I'd also like everyone to keep in mind that when you have a will, be mindful, keep the document in a safe place, preferably in a safe that is fireproof and it cannot be eaten by rats, and we can't at a point see what was in the document, because that document is a legal document and we need the original when we go to the office of the Master of the High Court to report your estate. So keep your will safe. Don't let your children color in next to your will. Don't play with the will close to a fire. Stay away from that. Keep it in a safe or in a safe place. Also then, a point to know that if you ever or are to dispute a will, let's say I'm not happy after the attorneys has called me and I feel like, no, this will is not valid. My mother could never have done that. She would have left everything to me. The burden of proof rests on you to go and prove that this will is not valid. So a lot of people would, out of maybe anger or disappointment, they will go and contest the will without having basic legal grounds upon which they are contesting the will, and only to find that then the burden of proof rests on them. And that just causes undue delays because you have no case. We go to court, you have no case. And then we are just perpetuating the winding up of the estate where it's just because of a person is unhappy. So that's just a point to consider. Now, what is the importance of nominating an executor? Hey, so an executor in a will. Sorry, I'm getting ahead of myself here. In a will, I, as the person drafting my will, or as the executor, as the testator, as we would call them, I have the responsibility to appoint an executor. Basically, an executor stands in my place in my estate and completes my affairs on earth. So they will go and collect all of my documents, go to the master, report my estate. They do everything to wind up my estate. So you can see that the executor plays a pivotal role. It ought to be somebody trustworthy and who also understands the process of deceased estates. You can't just put any person who doesn't know what to do. normally we would have your attorney appointed as the executor, or you can have your wife or your child appointed as the executor, but then they will give authority to an attorney to assist you to report the estate at the master's office. An executor is entitled, let's say it's an attorney who's reporting the estate on your behalf, they are entitled to a 3.5% executor's fee that is taken from the estate. And then also they are entitled to 6% of all income that they basically gather on behalf of the estate. So if there's monies that are owed to you and your executor is able to successfully collect those monies on your behalf, they are able to claim a 6% on that income collected. The executor's duties include reporting your estate, working with the master's office to obtain a letter of executorship, a letter of executorship. They notify your creditors of your death. They ensure that the liquidation and distribution account ultimately is lodged at the master's office, and ultimately that your heirs and the legatees receive what is due to them in terms of the will. Then a trustee and a guardian. So you can appoint trustees in your will if you have minors, people who are under the age of 18, and you are scared that obviously if you leave great sums of money to young children, or you don't just essentially want maybe somebody else handling the money on behalf of the child, but you'd really like that benefit to go to the child, you establish what we call a testamentary trust. In this testamentary trust, you appoint trustees. Again, these are people that should be well versed with deceased estates law. These are people that should also understand the responsibilities and duties of trustees. And these people essentially are there to preserve the asset and ensure that ultimately, when the asset is presented to the beneficiary, it has been preserved, or you've grown this asset subject to the limitations that you can put in your will. Basically, you are able to say, my trustees can rent out properties, they can open accounts, close accounts, they can sue, they can be sued, sorry, on behalf of the estate. Basically, they control the trust asset, but theirs is to ensure that it grows and becomes better, such that by the time the beneficiaries receive it, they are getting a benefit which has not deteriorated in any way. And then remember, then you also can appoint a guardian, a legal guardian in your will if you have children who are minors. Your guardian would then help your minors to take legal decisions. They would be the person who basically looks after the child in terms of a legal perspective, where they need to sign documents or claim from whatever policies. Perhaps if you have a legal guardian, they would assist the minor to do that. Keep in mind that as a parent, a mother and a father are natural guardians. So I can't put in my will that I don't want my husband to be, Utemba, to be a legal guardian to my children, because he is their father. Naturally, he's then a guardian. But if there are provisions, or if there's any reason why you feel like the surviving parent should not be appointed as a legal guardian, maybe you are the grandmother and you know things, you can go to the office of the family advocate or the children's court to see what or how they can assist you to ensure that the child is kept safe and that everything that they have, all their assets, are well then looked after. So let's look at what can I put in my will, provisions that I can have in my will. So in my will, I can say I can leave special items or cash to a legatee. A legatee is a person who would receive something once off. So I give my gold ring to my daughter. That's all that she receives. She's called a legatee, and she then gets that ring in terms of my will. You can leave a property to your children, or to a child or to whoever. But when you are leaving things like property, you must think, is the property bonded? If the property is bonded, you can't just deal freely with the property. You need to ensure that perhaps there is a life policy in place that will, at your death, cancel out the debt owed to the bank, and then you are then free to bequeath this special item or this house to your child. So you can leave basically anything to anyone in your will. Just be clear on the provisions, and if they are supposed to be receiving an asset and paying something into the estate, be sure that you're also having a discussion with that person to say, I leave this old classic vehicle to you on condition that you pay 20,000 Rand to the first beneficiary. I'm just making silly examples as I go along, but make sure that you have a discussion with that person so they don't benefit, but here they are finding themselves having to pay into the estate. In your will, you can we have what we call exclusion of marital regime. I leave something to my child, but I don't want this thing that I leave to form part of his joint asset in a marriage. I can expressly exclude that item to say this is a property that belongs to my child and my child alone, and it does not form part of any marriage asset going in future. So in my profession or in my day-to-day functioning, how that would work is where I have a title deed and I look in the conditions of my title deed and I can see, oh, okay, this lady inherited this property in terms of a will, and here expressly her husband is excluded from the ownership of this property by virtue of the provisions made in a will. So I know if she needs to come and sign whatever documents, I understand that this property vests in her alone. So that's how that would play out. Also, we have a term, a usufruct. A usufruct is where I leave a benefit to one person. For example, a husband leaves a house or a farm to his child on provision that his surviving spouse or the mother has the right to use and derive an income from that asset. So what that would look like is the ownership of the house vests in the child, but the right to use vests in the mother. So she then has what we call a personal servitude on that property. And then we call her a usufructuary. And then this usufructuary or this usufruct would terminate, for example, I can make provisions in my will to say, if you get married again, you lose the right to use or to derive an income from this property, or should you die, then obviously there's no right anymore because the holder of the right has now demised, and then that property would then be free of that condition, and there's a process in conveyancing where we are able to extract that condition, and then the property now vests fully in the son. Keep in mind that if there's a usufruct, the usufruct and the bare dominium. So the bare dominium is the person who owns the property. Let's say they wanted to bond the property. The son cannot just go to the bank and bond the property. He needs to take his mother because they both have a right to this property. So that's something that ought to be considered. Conditions continued. Then we have a term called fideicommissium. Fideicommissium is where one person inherits an asset. So I can put this as a provision in my will. I say, my first son will inherit this property, subject to the condition that should he pass away, the property is then to move to my second son. So that's how you see people having an asset where they say it's been in our family for generations, but now in terms of the law, we can only apply the fideicommissium rule to 2 consecutive generations. So we can't keep it perpetually anymore. We can only apply the rule to 2 consecutive generations. So you see, there's amazing things you can have in your will that make sure that people within your estate are looked after. And also, you know your personal circumstances, you know the dynamics of your family, you know what you need to be considering. So this would be important for you to think about as you are drafting your will or as your attorney is drafting your will. Remember, in a will, I can only deal with assets that are in my name at the time of death. I can't talk about, I was in the process of buying a house, and as I was buying the house, then I passed before I received transfer. No, I can't bequeath that asset. It's not mine. So I only bequeath things that are in my estate at the time of my death. Business owners, please remember, have shareholders agreements that make provisions for death. What happens if one of the shareholders, directors die? We normally would encourage them to have buy and sell agreements where if my partners are deceased, I'm able to go claim from the policy and actually buy his share, and then from the proceeds of the sale of the shares, that then goes back into his estate. So that's how we then make provisions for people who are in business. So ensure that you have these agreements, they are reviewed on a regular basis, and you have the necessary provisions even within your agreements. And then also to remember, if you're married in community of property, ladies and gentlemen, you can only deal with your 50% share. I can't say, oh, I'm going to leave my whole property to my kids. No, remember, your spouse, if you're in community, has a 50% stake in the estate, and you also have a 50% stake. Your will, if it is badly worded, can be disastrous. Get professional assistance. If you say, I leave the residue of my estate to my child, whereas you've got children, how do we interpret that? It's a bit disastrous now. So ensure that your will is well drafted and the person who's assisting you also really understands your intentions. Keep in mind, ladies and gentlemen, if there's shortfalls in your estate, they are paid by your heirs. What is a shortfall? When we go and we gather all your assets and your liabilities and we are looking, how does this person's estate look? If we see, oh no, we're short about 80,000 Rand to balance off this estate properly, or just to make sure that we don't have to report it as an insolvent estate or sell off any assets, we ask your heirs to please pay in money. It's a bit disastrous sometimes because it's people who sometimes don't even have the funds to pay in. So that's why it's important for you to be able to think about your estate. And in the process of estate planning, you'd be able to see, oh, if I carry on with this way of living, or if I don't reduce my liabilities at this point, I'm going to have a problem when I am no longer alive. And then where your liabilities exceed your assets, it's an insolvent estate. So the risk here is that your heirs and your beneficiaries may not even get anything, because the process with that we now have to follow is we declare this an insolvent estate, and then there are preferential creditors, all the creditors that have secured debts. What are secured debts? Things like mortgage loans is a secured debt. So they get preferential treatment. They are settled first. After those guys are settled, all your creditors with unsecured securities basically would then also claim from that estate. And after all your creditors have been settled, if there's anything, then your beneficiaries would get something. So we want to try and avoid that by all means necessary. Okay, then what happens if I don't have a will, or I don't go and draft a will? Look, I also just want to say this. We don't want that to happen because we work so hard. Some of you sleep late and wake up early. You are driving far, deep, and wide to ensure that you grow your assets, you grow your estate. But now, why do you want to leave things to chance with regards to how the estate will then wind up ultimately? So, what happens if I don't have a will? There you see Thabo. I hope you can see Thabo there. If Thabo dies without a will, point number one, if he has a wife and children, then the estate will be split between his wife and his children. So the wife would get a child's share or 250,000, whichever is the greatest. There's a formula that we use to calculate the child's share. I think I need to run now because I'm looking at time. So if Thabo dies and his wife is deceased, the estate then goes to his children in equal shares. If Thabo dies and he has no wife and no children, the estate will go to his parents. It will be split between his parents. If Thabo dies without a will and he has no wife and no children, and maybe his father has passed away, then his mother will inherit 50% of his share of his estate, and then his brothers and sisters will share the 50 that would have gone to his father. If Thabo passes away and he has no mother, he has no father, he has no children, the estate would then go to his brothers and sisters in equal shares. If Thabo has no mother, no father, no brothers, no sisters, then the estate basically vests in what we call this the guardian fund. And after 30 years, if no claim is raised, then the money becomes or is owned then by the state, and we don't want to find ourselves also in this situation. So what happens when you die? What do we do? What do we do as attorneys? Firstly, we will have a list of documents that we will tell your people to gather. So it's a marriage certificate, it's a death certificate. Excuse me. If you have a will, we'll ask them to bring a will. Then we draft and we complete the documents to report your estate. That's step number 2. And then after we've drafted those documents, but basically we'll also establish, is this going to be an LOA or an LOE? If you have an estate that is below 250, we basically obtain a letter of authority. So this simplifies the process of reporting your estate because you don't have to submit a liquidation and distribution account, but still your estate must be wound up. So that letter of authority will be issued to your representative. If your estate is greater than 250, what then happens is that we get a letter of executorship, and an estate must be reported 14 days after the person has died. We know that it doesn't happen, but the regulations or the laws stipulate that it should be 40 days. Then we place an advert notifying your creditors of your death. Then we obtain a list of all of your assets and liabilities. We basically go to the banks. We ask for various information. Then we draft a liquidation and distribution account. And this must be done 6 months after the letter of authority or executorship has been issued. Then ultimately, we submit the liquidation and distribution account to the master of the high courts. And then once approved, we can do the final distribution. Please note, the master of the high court is inundated with estates. This process, although the recommendation is that it should be 12 to 24 months, it can take longer. Even if you have a complicated estate, it makes it even worse or more difficult to deal with when we are dealing with the master's office. So keep in mind when you are either going through this process or you're dealing with attorneys, this process can take a while. Taxes that would be applicable, this is not my area of speciality. So in practice, what I do is I involve tax practitioners or specialists. Should you die, your estate is due to account for estate duty. That's 20% of the first 30 million of your dutiable estate and 25% on amounts above 30 million. It's called estate duty. Then also there's capital gains tax. At your death, how the law operates is that they view your assets as being sold basically to your deceased estate at market value, which then triggers capital gains tax. There are exclusions, which the first one is on primary residence. The first 2 million basically receives an exclusion of capital gains calculations. And on the first 300,000 in the year of your death, it is tax-free. Then obviously income tax, we all know it should be up to date even at the death of the deceased. So we would still need to ensure that we comply with our tax obligations. Now that we've gone through all of this, and I know I've been speeding across, I could spend days just speaking about this. What do we need to do? What am I suggesting or proposing that you do? Firstly, sit down and carefully consider your estate. Check your assets and your liabilities. Are you adequately insured? Are you solvent? Do you need to reduce your debt? Sit down and do that. In considering your estate, I'm also going to say, guys, if we need to come clean with certain things that are happening in our lives, come clean on those things. If you know you are over indebted, if you know that you have children outside of wedlock, when you're sitting down and you're considering your estate, essentially that is a consideration that must also factor in there, because you need to make provisions for those people. You need to be able to be clear and open on your intentions in your will. People mustn't be shocked when they read the will and find, oh my word, there are 3 people. Who are these people? We don't know them. You need to come clean on those. So estate planning and assessing oneself would allow us to achieve that. If you're married, speak to your spouse. I had an instance where a wife she was signing off things and didn't know what she was signing. And I was asking her, but why do you keep signing? She doesn't know. Go and check, man. Let's take out documents. Do we have a will in place? Speak to your spouse. And I specifically put their blended families. Imagine if you're in a blended family and you have legal guardian, or the court has granted you the rights of, now the word is now running away from me. Basically, the child can stay in your custody of the child. When something happens to you, that child, we need to, what's going to happen? Sit down and have those discussions. We don't want to find an instance where a child is now floating. Are we involving the other parent? What's going on? We need to have a plan. And that's why I think I specifically put blended families in place. Check your policies and your life covers. Are they still active? Are they valid? Do you have nominated beneficiaries? Remember, if you don't have a nominated beneficiary, it pays into the deceased estate. But if you have a nominated beneficiary, that money doesn't even go into the estate late account. It goes directly to your beneficiaries. And at the time of your death, nothing is more critical than people being able to have money to carry on with the normal things that they need to do and pay for on a daily basis. Check, do I have a will? When was the last time I updated my will? Do I need to remove a beneficiary? Do I need to add a beneficiary? Have I been recently divorced? Is my spouse removed from the will? Do I want them to benefit in terms of my will? You need to think about those things because we would hate to see you go. You've been divorced and you left everything to him. He's moved on with another person. He does not care about anything that relates to your life, but you were so negligent that you didn't go and update your will. Also, I would propose that you create a life on earth file. In this life on earth file, put all your important documents that you know will be needed should something happen to you. Life covers, life burial covers, your will, put it in there. And then tell somebody trusted. You don't have to tell them what's in there. You can say, if anything happens to me, go to number 14 Murray Street and open this closet and this something will be there. That's all you need to say, but let somebody know where they can get all of this important documentation. Don't delay, start now. Speak to legal professionals. Attorneys, if you feel like I don't have sufficient money to speak to an attorney, we do pro bono work. Come, speak to someone. Don't think just because, oh, I have an RDP house. An RDP house is an asset. If you know the dynamics of your family, that, there's infighting, think now. Don't leave a mess for us to try and resolve when you're gone. Make it easy for us by doing the right thing now. Speak to a banker. I don't think anyone would have to pay to speak to your banker about what can I have in place? What do you think I should do? Do you think I should get more life cover? Your bankers would be able to advise. And in the more technical estates where you know you're a business person and you're involved in complex structures, speak to a bookkeeper and a tax specialist, as well as an attorney and a banker, so that they can advise you and assist you to create a very good plan for you to be able to move forward should anything happen in your life, or for your beneficiaries rather, to be able to move forward. My closing statements. There is this quote that I read. It says, facts don't change because they're ignored. You can ignore everything that I've said today. It will catch up with you. You can call me, they call us prokurovers, and we've been named and called a number of things because we're trying to advise people to do the right thing, and it does sometimes come at a premium. But if you ignore what you've heard today or for the entire week, my dad always says, if you don't listen with your ear, you will feel it in your skin. When you feel it in your skin, we'll be there to assist you. But it could have all been prevented had you just decided to do the right thing at the right time. If you are intimidated by the thought of death, revisit your doctrinal beliefs on death. If you're still intimidated by the thought of death, that means your affairs are not in order. Sort out your affairs. But please do not bury your head in the sand. The last statement on my side, Ephesians 5 verses 15 to 16 says, see then that you walk circumspectly, not as fools, but as wise, redeeming the time because the days are evil. Guys, I'm looking at it from the context of everything that has happened this week. We need to be diligent people. We cannot walk around as fools, having been given and receiving all of this information that we've obtained today. We need to step up and do the right thing, because we are living in evil days where people just want to benefit from things that they did not rightly work for, or did not contribute in building. Don't be a victim. The power of testation, as I spoke about earlier on, is there to empower you. It shouldn't frighten you, but it should be there to empower you to be able to leave a lasting legacy for your children and your children's children, because the Bible even tells us that a wise man leaves an inheritance for his children's children. I hope that you have found some great benefit in tonight's discussion, and I'll hand over then back to the team to lead us. Thank you very much.
Thank you very much, Namfundo. Appreciate it. So this is the Q&A session now. We already have the first question up in the chat. Pastor Apani, you'll help me with the questions on the Facebook side because I don't have access to that. So this one says, my question is based on how a danger of contributions is linked, okay, how a danger of contributions is linked to insolvency, especially if there are any shortfalls on secured lending, for example, mortgages. Can the law allow any creditor to collect any shortfall, ID it happened a person or a company that was declared insolvent to start a new business and it shows success? Okay, I'm a bit confused.
I'm not understanding the question as well. Perhaps if the author can maybe word it a little bit more clearer.
Or maybe he can, I don't know, raise his hand so that he can be unmuted, so that we could understand. Moachi. I don't know if you're the one that raised your hand, but please unmute the hand that is up. So I'm just waiting for the IT people to unmute. Okay, whilst we wait for that, the second one is, can children of deceased parent from previous marriages have a claim on their deceased parents' assets?
So anyone who can prove that they were financially dependent and there is a basis for that relationship there would then be able to bring a claim of a claim against the deceased estate. However, it's for the master of the High Court then to decide if this is a valid claim. So anyone who can show a financial dependence on the deceased can bring a claim.
Okay, and then the other one is, you said that the will must be in writing. What is the effect of the video wills which state everything, but it's video recorded instead of written?
Okay, so on that one, I cannot comment. I've not read case law on video recordings. So my discussion was basically based on the provisions of the Act to say that the Act prescribes that the will should be in writing. Now, obviously, if you want to go, you can go to court and say this was the intended will of the deceased. The courts can make their necessary applications and then they will then decide, do we consider this the valid will for this person? That is a probability, but I cannot comment directly on the videos at this point.
Okay, and then the other one is writing a will through a bank attorney better than an independent or private attorney? Which is the best option?
The best option is writing a will, just point blank. The best option is writing a will, whether you choose to go through the bank or you choose to go through an attorney. I think it's nice with, let me say this very carefully. When you're looking at an institution that is assisting you with your will, you must be sure that in 10, 20 years' time, that institution would still be standing. Imagine if you come to there must be continuity. You must know that I will find all my legal documents, or I will still find the appointed executor. If you've appointed somebody within the bank, they have ways of reporting or of replacing people who would assist with the reportings of estate. So I would just recommend have a will, whether it's with a bank or it's with an attorney, but just make sure that you know that the person will that institution would still be around should you need them to be of assistance in reporting of your estate, and if you've appointed one of the people within that organization as an executor, that they can still play that role.
And then the other one is, how would I incorporate assets in foreign countries in my will? Let's say I have properties in another country. How does the tax apply in this case?
Okay. So with regards to tax, I'm not going to make comments there because, like I said, in practice, I always would outsource the issue of tax to tax specialists. But look, when you have an asset, even in another country, I would even propose that you make provisions for that in your will to say that your legal practitioner must then just establish what are the laws of testation in that country and ensure that in your will you are able to at least comply with those requirements so that that document can then be utilized for those purposes.
Okay, we have a hand up. Timber, um, can you just maybe raise your hand so that the IT team can see you and they can unmute you? Okay, whilst we wait for Temba to raise his hand, so he is unmuted. Then the other question is, okay, so this is more of a scenario that has taken place. So we have submitted all documents of my late mom, and now her bank is delaying to pay out to estate account, and it's delaying our attorney to finalize the estate. What can we do?
Yeah. So I would propose a one-on-one discussion with that person outside of this platform to establish why is the bank delaying. There must be a reason why the bank is delaying in paying out the funds. And once we have established why the bank is delaying, we would then be able to, if there are invalid grounds for this delay, we'd be able to escalate within the bank. Alternatively, there are other means through which we can apply a little bit of pressure, but we'd need to understand why is there a delay. So I think it's difficult for me to just answer on what immediately to do without understanding the reason for the delay.
Okay. Um, Sorry, I'm just responding to what you said so that she can just speak to the pastor to get your contacts. Um, so it says here, thank you very much for the useful information. My question is, in most cases, only or many people believe that only men must write a will. How important is it for women to have their wills drawn as well?
We can't fight so much for and advocate for women's rights and then we're leaving it to the men again. What's the point? Why do we have all of these rights? So I would encourage a woman, a man, a young person, an old person who falls within the category of a person who can go and have a will drafted, get your will drafted, just to ensure that things happen the way you wish when you are gone. If you're married in commutative property and your spouse perhaps doesn't want to write or draft a will, remember you can still speak on your 50% share, but it would be good in my opinion, I don't know, I have other colleagues who are on this call. It would be good, perhaps, in my opinion, to say if you're married in commutative property, have a joint will that specifically states that if this one dies or if what should happen when somebody dies, basically.
The other one is, okay, given how families fight over wills and all that, how can one safeguard themselves that the one will that you've written will be the only legal will that will be accepted?
So that's where I would involve maybe an attorney or the other lady was speaking about a financial institution where they know that should something happen to you here, all your people must know. You need to all go here for you to know what must happen with regards to my estate. So yeah, I think you just appoint an attorney and let everyone know where your things are sitting, if it's safe to do so.
I think this is more of you and the pastor's question. It says, does the church assist in writing a will and keep it? I don't know who's the relevant person to answer that.
Yeah, I don't know why. I like the question. Thank you for the question. I don't see why we should leave it to the church, though. There
Okay.
are attorneys who are in the various churches, and I'm sure during the month of September, they all get involved in the Wills Week, where you are able to approach any one of them to assist you to draft a will. But look, even if it's not Wills Week, go and speak to somebody that you know is a legal professional and ask, can you assist me to draft a will? I'm actually going to put it out there today to say, I am prepared to assist anyone on this call to have a will drafted for free.
Okay. I think they all heard that. Um,
And I know
so
my
here,
friend Mandla Mashiani is also prepared to assist anyone who needs to draft a will for free.
I think this is the second last. Okay, so it says here, my children are all grown-ups. One can state what I want being done. Okay, so wait, it's bullets. Okay. My children are all grown up. Firstly, um, what I want being done with my property should I die. Secondly, can I appoint one of my children to be responsible to carry out the instructions that are in the will? And can I also include my grandchildren if I want them to benefit from my will?
Yes. So you can appoint anyone to be an executor, and you can appoint your children, yes, to be an executor, and then you can leave anything to anyone, anyone. You can leave something to the church if you want. You can, that's the power of testation. You get to dictate from your grave what must happen to your assets.
Okay, I think Mandla is back because your hands are in the chat, but I don't think the IT people can see, so they can unmute you. So if maybe you can Temba, sorry, not Temba. Because this is your third time raising it, but I don't think they can see your hand being raised in the chat. I'm just going through all these. I think that's about it. So Temba, if you can maybe try speak so that they can unmute you. And then there's also Tammy. So we've got the last two hands before we wrap it up. Tammy and Temba, please raise your
They
hands
can
so
unmute
that they.
themselves.
Okay. Temba, Tammy, whichever one.
Good evening. Can you hear me?
Is this Temba?
That's Temple, yes.
Okay.
Yes. First of all, thank you for such a lovely information. I think mine is to just to find out if it's possible that we can have a private chat. I have an issue with regard to an estate of my uncle, so I'm helping out my uncle's wife with regards to that. So I think this will probably come in very helpful for her if maybe we can speak privately.
You're welcome to take my number from the pastor. I think, yeah, you're welcome to take my number from the pastor, and we can definitely connect privately.
All right, thank you. We'll do so.
Okay, Tammy. Tammy was the second hand.
Greetings. I hope I'm audible. Am I audible?
Yes, you are.
Okay, thank you. Greetings. I have two questions that I'd like to ask. The first one is, how long does a will of a deceased, how long does a will of a deceased how long does a will of a deceased take to pay out? And another question is, when someone who's deceased has put you in his or her will, how will you know that you are in the will if the person has been deceased for more than a space of 6-12 months?
12 months. Okay. So the first question is, you asked how long does a will take out to pay? In the discussion, I was just explaining that the process of winding up an estate can take a long time because we are dealing with the Office of the Master of the High Court. There are a lot of delays in the various offices. So we see that it tends to take a little bit of time. I mean, currently I'm dealing with an estate over 5 years and it has not been finalized. We're just about to finalize. Sometimes it's 12 months and the estate is finalized. It also just depends on the complexities that are involved within that deceased estate. If there are policies, however, that were due to pay out in terms of that deceased estate and there are nominated beneficiaries, those policies normally pay out immediately after the compliance with their claim requirements. Then those policies would pay out. So I think it varies from institution to institution. So I think you are referring to the final payout from the entire estate. My brother, it's very difficult to gauge, and it's just dependent on a number of factors. The ideal time that the law has is around 24 months, if I put it that way, but we've seen it going on for longer. And your second question was with regards to how would I know if I'm in a will? So basically, if the correct processes are followed, once a person is deceased, there's what we call the reading of the will, where you'll sit at the attorney's office, the will is taken out, and basically all the beneficiaries are called. What we do is in our practice, we attach a list of the beneficiaries to the will to say when something happens, we call all of the beneficiaries, and then we read out the will in the presence of all of the beneficiaries who are there. So you would be called by an attorney, you would be called by the bank, and if perhaps you are suspecting that an estate has been reported and you are perhaps a beneficiary, you can actually even go to the office of the Master of the High Court and make an inquiry. Has this estate been reported? Who's the reporting attorney? And if you are a child, or maybe you have been told that you are a beneficiary, you can go then to that office and ask what is happening on this estate.
Okay, thank you so much. Thank you.
Okay, let's take the last two hands. The last two hands. So I'll start with my Shitisho and then go to Luke. Those are the last two hands.
No, thank you very much. Am I audible where I am?
Yes, you are.
Thank you very much. Just for a few, just a second question. When you draft a will, what I have seen is that there are people who, when they are children, most of the Christians, Adventists sometimes, Adventists in particular, when their children are not Adventists, they give there is what they call they give the church 100% of whatever they have, and they say because my children are not Christians, and therefore they don't deserve to have anything. Maybe the pastors can help us here. And secondly, maybe as a warning, there is what is called, there is a church company, I may not mention it by name here, which is always, the church is always encouraging that the church members must put a will in the name of that company, which is not really correct. They say church members is the only legal entity which the church has, but it does not really 100% belong to the church. It has got its own other issues. As I said, we will not discuss it here. But maybe the pastors can help in the future to warn the members that if you want to draft a will, you want to give access to the church, it's better to specify where rather than to go to that company and give them all assets. People have done it before and they don't even know where their assets are. Thank you very much.
Okay, thank you. Luke.
Thank you very much for the informative talk. I'm not a legal person, but I heard that in the last resort, if you don't have you are about to die and you realize that you have no will, you can have a recording. And that recording, you say what how your estate should be divided. And that recording can act as a will. I don't know. Yeah, maybe clarification on that one. Thank you.
Okay, I guess that was a comment. I don't know if it was a
Yeah.
question.
I think it was a comment. I think I had just stated earlier that I was looking at the requirements for a valid will. So there's a comment that says the clerk's will was a video recording. So that's I would believe under case law. Can I not comment on that? And can I then read up on that and then just provide it to Umfundisi to share with the church folk just with regards to recorded wills? But again, I think we don't want to push it to the point where we are having alternatives where there's a prescribed manner that we ought to follow. Where possible, do things in time so that we don't have to resort to means that fall outside of the recommendations. Yes, there are exceptions to the general rule, but the general rules are there to guide us when we have sufficient time to ensure that we do what is right and accordingly. So I don't want to speak too much on the recorded wills. My discussion was on the provisions of the Wills Act. I don't know if any of my other colleagues are on the call that would like to maybe answer that question. They're welcome to do so.
Thank you very much. Appreciate the presentation. So I'll ask the pastor just to beam the contact details of all the presenters till date, so that people can take screenshots and pictures before we do our announcements. So These are the numbers.
I think maybe
Okay.
you can continue with the announcements I'll just leave the contact numbers as you do announcements.
Okay, no problem. So a few reminders and announcements. Firstly, I think tomorrow is the last day of our week of prayer. So we'll start at 7 again, at the same time. So this program will be streamed live, Facebook, from 7 till 8 p.m. Please try logging in 10 minutes earlier. Secondly, the meetings are being recorded and all recordings will be sent on various social media platforms. This includes the TOC Stewardship WhatsApp group, the TOC WhatsApp platform, and the local church's emails. The same will happen with the presentation. And then the third one is remember on Sabbath, the 8th of February 2025, the Stewardship Department will be hosting the Master Steward graduation at the Spring Civic Hall. Please note that the program starts at 9 a.m. and will end at 4:30, the latest 5. So this graduation will be held at the Spring Civic Hall. It starts at 9 and will end at 4:30, the latest 5. We are encouraged to bring our own lunch, so please note that. Please bring your own lunch. Nomfundo, can you close for us in prayer? And do have a great evening, everyone. Thank you.
Let us pray. Our Father who's in heaven, Father, we just want to thank you for the empowerment that we receive, because even the Bible tells us that where the Spirit of the Lord is, there's freedom, and we are thankful for this freedom. And we ask, oh Father, that we are not negligent in the things that you present before us, but in everything we do, let us do it to the glory and to the honor of your name. Bless all who are present today. In Jesus' name I pray. Amen.
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 Everyone, and enjoy the rest of your evening.
Amen.
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 Amen. Amen.
Amen.
Amen.